Please be seated. The court is now back in session. And the chamber would like to hand the floor over to the defense team for Keo Sampon to continue putting questions to the witness, Mr. Steve Heder, and that is to conclude your questioning time within a 10-minute time allocation. You may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. Mr. Heder, we are coming to the end of our examination, and I would like to deal with the last point with you. At the hearing of the 11th of July at 15 hours 33, the co-prosecutor referred to a speech by Pol Pot delivered in 1977, and this is related to your article, Pol Pot and Keo Sampan, document E3/3169, and it is footnote 65. And you refer to this speech in that footnote, titled in English, I'll read out the title in English.
Long live the 70th anniversary of the Communist Party of Kampuchea. Speech by Pol Pot, Secretary of the Central Committee of the Kampuchean Communist Party, delivered on September 29th, 1977. Et j'aurais très bien pu le citer en français parce que...
I could very well have read it in French, but again, that is the title. Would you leave, Mr. President? May I show the witness document E3/147 to have him confirm that that is indeed the article, and I would like to refer to 2 extracts of that article.
Yes, you may proceed.
Le premier extrait se trouve...
The first extract has the following ERN, S in French, S000012477, and in English it is 0012669, and in Khmer 000192556.
Et se poursuit sur la page suivante.
And it continues on the next page. But before reading the extract, I will... No, just a minute, please.
Donc, je vais lire cet extrait.
So, I will read out the first extract. But before I do so, could you please confirm whether that is indeed the speech you refer to in your footnote in your article? Was that the speech from which you extracted the paragraph in your book, Pol Pot and Keo Sampan?
Yes, it's the speech, but it's not from this document. As I think I said in my earlier testimony, it's from a Khmer version of this document, not the English translation that's provided here.
Est-ce que vous préférez avoir un...
Would you prefer to have the Khmer version? In any case, the Khmer version will be placed on the screen, and it will be simpler for you to refer to it. The passage with the ERNs I mentioned is as follows, and it is the last paragraph. In that paragraph, Pol Pot is explaining the topic of his speech. What are the goals of that presentation? Consequently, it is not a question of talking about a meeting today, but rather a reflection session and a study session on our revolutionary movement under the leadership of our Communist Party of Kampuchea. End of quote.
Est-ce que dans la version que vous...
In the version of the speech you read, was there this paragraph? And does it correspond to the manner in which this speech was developed within the context of the Communist Party of Cambodia, the development of the Communist Party of Cambodia?
Yes, I think so, yes.
Maintenant, avant de passer au...
Now, before I read out the next extract, I would like to read a passage from your article, Pol Pot and Kyo Sampan, the same that was read by the co-prosecutor at the hearing. The ERNs are as follows in French: 00722 081. In English, 00002762, and in Khmer, 00711 And this is what you wrote regarding that speech. In this speech that was delivered, and it is the last but one paragraph before the end in French, in the middle of the paragraph. In this speech, delivered on the 27th of September 1977, Pol Pot presents in detail his views on the communist movement in Cambodia, its successes and failures. He publicly expresses his specific confidence in the two men who were involved in the purges throughout the year, Nunchi and Kien Sampan, the only ones who were leaders of the party worthy of praise. Some describe Kyo Sampan as a distinguished intellectual, paying homage to him, underscoring the fact that he was arrested and imprisoned because of his political activities. End of quote.
Je voudrais maintenant passer au deuxième paragraphe.
I will now read out the next paragraph, which I would like us to look at. That is the passage of the speech by Pol Pot in which he refers to Kyo Sampan. This is document E3/144. And the ERNs are as follows: S0000012485 in French. In English, 0012674. And in Khmer, 0001927. And this is the passage in which he refers to Kyo Sampan, referring to him not by his name but by the designated state candidate. And it is in French, page 25, third paragraph. The First Party Congress met on the 30th of September 1960 in Phnom Penh, while the enemy's oppression was raging. As an example of the situation then, I would like to say that our comrades who are great intellectuals, like the comrade president of the State Presidium, were also arrested and imprisoned. If the enemy did not hesitate to strike at great intellectuals, it would not refrain from striking workers and simple peasants and ordinary people. End of quote. My question to you is as follows. Is it on the basis of this passage in Pol Pot's speech that you wrote the paragraph relating to the way he was characterized as a distinguished intellectual and the tribute that was paid to him, according to you, in that speech of the 27th of September 1977? Is this the passage you are alluding to?
Yes.
Est-ce que nous sommes d'accord?
Do you agree with me that in the extract I read out to you, the extract of the speech by Pol Pot, he was talking about the situation at the time in 1960 and citing the example of Kyo Sampan as he talked about the situation of great intellectuals. Do you agree with me that this paragraph is talking about a particular historical context?
Could I see the Khmer again?
Je vais demander qu'on puisse l'afficher.
May I request that it be placed on the screen? Would you leave, Mr. President?
Ah, j'ai peut-être oublié de préciser pour...
I have forgotten to specify for the record that the Khmer version does not feature in reference E3/144, but it's in the reference 4.40, which is the previous reference for this document. And unfortunately, I don't know why they didn't assign an E3 number to this document in the Khmer version. But the transcripts of these documents are correct.
Yes, you may proceed. Court officer, could you assist the witness?
Est-ce que vous avez pu prendre connaissance du...
Have you been able to read the document in Khmer and to understand its meaning? So let me put my question on this paragraph. I see that the mention is made of a tribute in the article, but we are not talking of the context of the situation in 1960 vis-à-vis intellectuals. Is that not the situation depicted in that article?
Well, it certainly refers to the situation as it existed as of the time of the party Congress, said to have occurred in September 1960. As for the dating of the tribute, I think that's at least open to interpretation. Like there's no plural, there's no tense in Khmer as such, but the comrade is described as being a major intellectual, and that appears to me at least to be at least as much a reference to the present as to the past. So whether the tribute is to the person as of 1960 or the person as of 1977, one, I suppose, could quibble, but it could very easily be read as meaning the person as of September 1977. But with reference to their past activities.
Et juste pour terminer.
And to end on this point, the last paragraph as regards dates you may have on the date of the tribute in quotes. When Pol Pot says, if the enemy didn't hesitate to strike at major intellectuals, nothing would prevent them from clamping down on workers, simple peasants, and ordinary people, end of quote. Perhaps let me continue to place this in context by reading the next paragraph. It was in this bleak situation that we successfully convened our party's first Congress right in the railroad yards of Phnom Penh itself. Placed in the context of the entire speech and in view of the following paragraph, are we not, when Pol Pot talks of great intellectuals, while describing, he was describing the situation at the time, and he was not paying particular tribute to Khieu Samphan. Isn't that correct?
Not by my reading, no. I mean, he's paying tribute to someone in the present, indeed in part or with reference to the past, but the tribute to my reading of these passages is still in the present. You may beg to differ. That would be my reading of the way in which those passages are formulated. And it's striking that the description of the comrade as an intellectual is not formulated in such a way as to make it specifically clear that it's a former intellectual. It appears at least as much to be a reference to the present, which may have its own implications, other implications, but that's the way it reads to me.
D'accord, et ça, c'est selon.
Very well. According to this, it was according to this perspective that you wrote the paragraph in the article I referred to a while ago and which I read out to you. Is that correct?
Yes, that's correct.
Et ce sera ma toute dernière question.
This will be my very last question to you. As part of your activities before, during, or after your time at the tribunal, whether you were working for the co-investigating judges or the co-prosecutors, and as part of your activities when you were researching your articles, can you tell us what was the revolutionary alias of Khieu Samphan and whether you heard any others?
Well, I've always heard from, I think, safe to say, or close to extraordinarily safe to say, every source, that the name in use during the 75-78 period was Ham. There was a new pseudonym for him and others that were put into use after January 79. I don't specifically recall what it was, but these new pseudonyms, except in the case of Pol Pot, didn't stick very much. People continued to refer to individuals by the pseudonyms by which they were known before January 79.
D'accord, mais pour la période.
Very well. For the period from 1975 to 1979, the only pseudonym you knew was Hem. Is that correct?
Yes, that's correct. And I suppose the question has to do with something that was testified by Gangakio alias Duik. And I can say that the alias that he talked about, I have never heard before or since anywhere else.
Je vous remercie de ces précisions et je vous remercie de la...
Thank you for these clarifications, and I thank you for the patience you showed proof of throughout your examination. I am done, Mr. President.
Thank you, Counsel. And thank you, Mr. Heder. Mr. Heder, the hearing of your testimony has now concluded, and you are now excused from the courtroom. We are grateful for the time that you spent to testify before this court during the last few days with patience and best effort. Your testimony may contribute to ascertaining the truth in this case. And the trial chamber wishes you good health and good luck. Court officer, in collaboration with Visu, please make arrangement for Mr. Haidar to return to wherever he wishes to go. And Mr. Haidar, you may now leave the courtroom. Thank you. President, the chamber would like to give the floor to the prosecution to respond to an article in the Phnom Penh Post that has been submitted by the prosecution to the trial chamber through email. You may proceed.
Thank you, Mr. President, and good morning, Your Honours. As the President just indicated, we did a short while ago forward this particular letter to the editor of Phnom Penh Post to all parties. Your Honours, we asked for time to make submissions in relation to this letter. It was published this morning in the Phnom Penh Post, so the edition of the 18th of July, on page 16. It is a letter entitled Khieu Samphan is forced to remain silent. It's signed by, or issued in the name of, Anta Gesay, Kong Sam On, and Arthur Verkin, counsel for Khieu Samphan. The reason we made this application to be heard, Your Honours, is both in light of the fact that we are approaching the conclusion of evidence, but also in light of the scandalous nature of the allegations made in a public fashion, and our view that allegations of this sort must not only not be tolerated by this court, but should also be addressed and dealt with in accordance with law and in accordance with accepted standards of ethics. It's a rather long list of allegations that this letter contains, and I will try to deal with all of them one by one. And of course, I'm at Your Honour's disposal if you wish to hear from us further. But our application will be, pursuant to Rule 35, that Council be formally rebuked and that a formal reprimand be issued and further measures be taken against them in light of what in our submission is a clear attempt to interfere with the administration of justice and conduct that falls far below the ethical and professional standards that Council are required and expected to uphold in this courtroom and before Your Honours. I'll deal with the allegations one by one because I do believe, on behalf of the Office of the Co-Prosecutors, it is important to set the record straight at the earliest possible opportunity. So the first allegation that is made in this letter is that Your Honours have heard dozens of witnesses and admitted as evidence thousands of documents while ignoring many concerns expressed by the defence. This is a clear misrepresentation of the record of these proceedings. At every turn, the defence have been given an opportunity to challenge prosecutions and indeed civil parties' documentary evidence, as well as being given an opportunity to submit their own documentary material. Of course, at every turn, they have availed themselves of those opportunities, as have we. By way of a very brief recap, in this court, we had witnesses who testified to the origin and provenance of documentary evidence, 2 witnesses from DCCAM. We had extensive hearings on each of the annexes that the prosecution put forward. The defence were able to make written and oral submissions on all of those documents. As to the allegations that somehow defence concerns were ignored, this is clearly false. Reasoned decisions were issued in relation to every annex, as well as separately in relation to witness statements, which were the subject of further submissions yesterday. There can be no credible allegation that anyone has been prevented an opportunity or that anyone's concerns have not been considered. It is one thing to disagree with a decision, following which, of course, counsel have the possibility, of which they've been reminded on numerous occasions by Your Honours, of appealing to the Supreme Court. That is one thing. But to make false allegations about effectively being gagged, ignored, or prevented from making submissions is unreasonable, it is unethical, it is unprofessional. Further, on defence's concerns with documents, I would remind the defence that on numerous occasions where we've made applications for new material to be admitted, they were permitted to make written and oral submissions, and in fact, Your Honours declined our request to admit a number of documents. Among them, a series of documents from Amnesty International, US cables predating the April 1975 period, and new witness statements, such as a statement of witness Mayor Sworn, who of course testified before Your Honours in October 2012. The second allegation, and I will slow down. I will repeat the name of that witness for the record, witness Mayor Sworn. The second allegation relates to an alleged denial by Your Honours of a possibility of, quote, a real discussion on the mountain of evidence admitted. One wonders when reading these words whether counsel for Khieu Samphan are operating in a parallel reality. Only recently, on the 9th of July, having sought an opportunity to make presentations on key evidence, they failed to do so. I stood at that juncture and asked Your Honours to consider giving counsel extra time, and Your Honours did so. Both the President and Judge Laverne addressed Counsel Verkin, asking him on several occasions whether he intended to make presentations on key documents and whether he intended to avail himself of the opportunity given to him by Your Honours to respond to the key documents, the mountain, as they describe it, that the prosecution has put forward. He declined that opportunity. He declined that opportunity, and this morning he seeks to mislead the public and everyone else observing these proceedings as to what happened here in court, to mislead the public as to their own sloppiness and as to their own failure to take the opportunities given to them, including opportunities specifically offered to them for extra time to make submissions on documents. To make this claim is simply outrageous against that record. The third complaint relates to the severance order. And it is always amusing to see the defence now take issue with the severance order, having in fact supported it throughout this trial. And this is what they say. Quote, while hindering the defence from discussing the evidence presented in the course of the first trial, allegedly devoted to the policy evacuation, the Chamber surprisingly announced it would adjudicate, within the realm of the first trial, the responsibility of Khieu Samphan with regard to all criminal policies. They go on to say that this is indeed shocking. Their words. As a matter of record, the scope of this trial was defined in the severance order in September 2011. Counsel for Khieu Samphan did not question that decision, nor did they seek its reconsideration. In fact, they opposed the prosecution's appeal to have the scope of trial revisited. And here, I will refer to their response to our appeal because I believe it is important to put on the record, again, just what the defence's position has been throughout this trial. In their response to the co-prosecutor's immediate appeal of the severance order, document E163/5/1/9, at paragraph 31, counsel make it clear that they in fact fully understand the scope of the severance order and the scope of the trial. Quote, however, the trial chamber did not issue the severance order with a view to summarising the indictment, but rather to permitting a detailed review of all its components. As the trial chamber has previously explained, in issuing the severance order, its reasons were, going to number 2, to ensure that the first trial encompasses a thorough examination of the fundamental issues and allegations against all accused. And 3, to provide a foundation for a more detailed examination of the remaining charges and factual allegations against the accused in later trials. The defence then go on to argue that, in fact, this is a decision that was perfectly reasoned and fully understood by them. Paragraph 46. The defence does not agree with the arguments that the trial chamber failed to provide adequate reasons. Paragraph 49, second sentence. The truth is that, contrary to the co-prosecutor's assertion, the trial chamber clearly gave adequate reasons for its decision by taking into account the risk involved in extending the scope of case 002. An almost unbelievable exercise in hypocrisy. Having supported the order throughout this trial, having failed to raise any issues in relation to the scope of the trial, having opposed, in fact, appeals on this issue, they now turn around and say that you have placed them in a state of confusion and that they have not been able to effectively engage and defend their client in relation to these policies. The further allegation is that, and this is the fourth allegation in the letter, that the dice is loaded, that the chamber has never been interested in hearing what the defence has to say. Again, an outrageous and false claim. Just a couple of aspects of this trial for everyone's benefit. They have been given an equal time to question all witnesses. They were given opportunities to propose their own witnesses, and they did, and the chamber called those witnesses. They were given opportunities to make document presentations. They declined them. In fact, they've made no complaints about any substantive aspect of this trial until this very last-minute change of heart by Khieu Samphan. And it is important to recall that it was as recently as the 27th of May, against that entire trial record, that Khieu Samphan confirmed he intended to continue testifying. As recently as the 27th of May, when he made that confirmation, no issues were raised about supposed allegations of fair trial rights. No issues were raised about an inability to put their case forward. They made a strategic decision, and that is their right. And in our submissions, it does draw certain implications for them. but it does not entitle them to misrepresent the record as they have sought to do. And the final misrepresentation in this open letter relates to the circumstances leading up to Khieu Samphan's refusal to continue testifying. The allegation here is that the Chamber has denied all of Khieu Samphan's requests in relation to the mode of his examination. Again, not true. Your Honours initially accepted some of the proposals and denied others, which in our submission is an entirely reasonable decision, a decision consistent with every case ever prosecuted at any international tribunal. But having made those initial accommodations, and having then heard that Khieu Samphan was refusing to continue to testify, Your Honours gave us an opportunity to offer further accommodation. Contrary to the article, those accommodations did not relate only to extra time to prepare. We also offered to give Khieu Samphan a list of topics on which he would be examined. None of that information appears in this article. None of that information is shared with the public as Khieu Samphan seek to put forward this series of misrepresentations about supposed breaches of rights. And that brings me to my conclusion and our application. It is our respectful submission that by issuing this false and misleading statement in relation to ongoing proceedings before Your Honours, Council have engaged in a blatant attempt to interfere with the administration of justice and to bring the administration of justice into disrepute. This falls far short of the standards of ethics, professionalism and integrity that are required of Council. And if I can refer to just one document that is relevant for present purposes, and it is the UN resolution on the basic principles on the role of lawyers. It's a United Nations document. It applies to everyone in this courtroom. The document number is UN-Doc A/-CONF.144.28/REV.1. In fact, one shouldn't have to read this in a court of law with professional counsel. But we will read it because it's important to remind them of the duties they have failed to fulfill. Article 12, quote, "Lawyers shall at all times maintain the honour and dignity of their profession as essential agents of the administration of justice." Article 14, "Lawyers, in protecting the rights of their clients, shall at all times act freely and diligently in accordance with the law and recognised standards and ethics of the legal profession." Pursuant to Article 23, those same standards of ethics apply when counsel engage in public activities, such as discussing the administration of justice in newspapers. Your Honours, this article contains outrageous misrepresentations of fact. It is a cynical, calculated attempt to mislead the public, as I said, to bring the proceedings before the court into disrepute, and to make allegations, false allegations, in relation to a matter, specifically the matter of adverse inferences, which is presently under consideration by Your Honours. It is indeed an appalling failure to act professionally and ethically, and as such, it should be sanctioned so that a strong message can be sent by this court that this is not permissible behaviour and that it will not be tolerated. We apply, pursuant to Rule 35, to Your Honours to issue a formal reprimand or rebuke to Counsel Kong Sam-on, Ante Gise and Arthur Verken, to refer them to their respective bar associations, to notify the Defence Support Section of this matter, and of course to issue that reprimand and that reference as public documents so that the public record can be corrected and these outrageous misrepresentations put to rest. That is our application, Your Honours. And if there are any further questions that you wish me to address, I'm at your disposal.
The President, thank you, Mr. Prosecutor. Madam Lead Co-Lawyer for the Civil Party, you may proceed.
Yes, Mr. President, thank you for this opportunity to take a few minutes of your time, because I wish to react to this column or editorial that seems to me to be particularly serious and, very clearly speaking, is something that is false and something that is disloyal. I wish first to make a few introductory remarks. The first is that when we don't wish to speak, it's always easier to justify oneself by saying that we are prevented and that we're forced to remain silent by someone else. And that's exactly what is happening here. And my second remark is that I infinitely regret the form that was chosen by the Queue Sans Pant defense to voice their opinion in that way. We had a debate on the same topic here, and since the Chamber did not support the defense is turning to a newspaper which I don't believe is an appropriate place for an adversarial debate. And in this paper, we don't have to justify everything point by point. And it's also a place where it's possible to misrepresent what is happening. And this is what's happening here. I think that this article is an insult to the Chamber. Beyond this Chamber, it's also an insult for our proceedings that we've been having for the past 2 years. And beyond this, it is an insult to the civil parties we are representing here, and an insult to the Cambodian people, and this should be reminded. Of course, I support the co-prosecution here regarding all of the allegations made by the Queue Sans Pant defense. I share the prosecution's point of view. Each one of these allegations is false, not grounded. It was already evoked here, and it was already rejected by this Chamber. I wish simply to add 2 small comments regarding 2 particular allegations. Regarding the documentary mass that we're facing here, I am asking myself what the Queue Sans Pant defense was expecting by coming to such a trial. Aren't civil law lawyers surprised by the civil parties here who have joined? I hope not. Is the Queue Sans Pant defense surprised by the number of documents? Well, I believe that the more documents we have, the more impartial we can be. If Nuncia or Queue Sans Pant would be prosecuted on the basis of 5 documents, then there would be a problem of partiality and justice. Now, my second comment regarding the allegations, regarding the 5 policies. In this article, I read that your Chamber is accused of having suddenly introduced at the very end of this trial the discussion on these 5 policies. This is false. As of your severance order, you mentioned the paragraphs regarding the existence of these policies, and often you insisted during the proceedings on this to remind us that we were going to discuss the existence of these 5 policies. So this assertion is blatantly false among the other false assertions. I believe that what the Khieu Samphan defense team is doing today is nothing else than an attempt to try to withhold the chamber of its credibility at the very end of these proceedings. It is nothing else than a strategy. The reality, which I wish to remind, is as of the very first days of this trial, I remember that Nuon Chea and Khieu Samphan promised and Mr. Khieu Samphan in particular insisted that he would, and he said to us that he would speak at the end of the trial. He said it, and he promised it not so much to the chamber, but to the civil parties and to the Cambodian people. In any case, those were the words he used back then. And he had many opportunities to do so, and your chamber offered him the opportunities for him to do so, as well as to his counsel. I was maybe a little less flexible. I believe a trial is not simply moments when we consider abstract legal issues. It's not something only for jurists and specialists. It's something that is for society at large, for the Cambodian people, for the international community, and for the victims, for the civil parties representing here all of the victims. And I believe that today, this encounter that we have, which Nuon Chea and Khieu Samphan are refusing, that is their choice. But what I find particularly dishonest is that that choice that they made today, they are trying to have the chamber bear the responsibility for this choice, but not by themselves. I have no specific position on the sanction requested, and this the chamber, of course, will assess. But what I want, however, to underline today is the seriousness of what's indicated in this article, which was brought to us little by little over the past weeks and over the past days. I believe that the accusations here against your chamber are an insult against you, and also an insult against the civil parties and against everybody coming here every day to find out what has happened, to hear what has happened, and to understand what has happened. And I wish to stress how serious the matter is. Thank you.
President, thank you. The National Lead Co-Lawyer for the Civil Party, you may proceed. Counsel Pejong. Good morning, Mr. President. Good morning, Your Honors. I have a few additional points to my esteemed colleague from the prosecution and my international lead co-lawyer for the civil party, but I do not comment on the legal aspect, but I speak on behalf of the civil parties. I would like to assert to the chamber concerning the expectation of the civil party from the accused. At the very beginning, particularly during the investigation stage, the co-accused once decided to exercise their right to remain silent. They did not respond to the question by the co-investigating judges. And this move aroused suspicion by the civil party as to why they decided to do so. But then at the start of the trial by this chamber, the co-accused, particularly Mr. Nguyen Chia and Mr. Kieu Sampon, started to respond to the question by the prosecutors. And this move made the civil party find that it is important that the co-accused respond to the question, because they want the co-accused to respond to the question. They have asked us as their representative why the accused refused to respond to the question. How can we ascertain the truth without the response from the co-accused? So as the lawyers for the civil parties, we from time to time have to respond to the query by the civil parties. Following the death of Mr. Ieng Sari in last March, certain civil parties have made a request to the lead co-lawyer for the civil party, and they have made a public appeal as well that the co-accused should respond to the question, and they should enlighten the court, and they should understand that their testimony, their response to the question are very important to them. Now, we haven't met all the civil parties, but I am sure that their recent move will make the civil party most unhappy. I have not much thing to add, but on behalf of the civil party, I still earnestly request that the co-accused be required to respond to the question that will help the civil help appease the civil party, and in addition, it is also useful for the historical record for the younger generation to come to learn about their past history. Thank you, Mr. President. The President. Thank you. The hearing of the testimony of witness Stephen Hedder has come to an end, and the Chamber notes the application by the co-lawyer, by the co-prosecutor, and the observation by the lead co-lawyer for the civil party concerning an article published on the Phnom Penh Post today. The President. The defense team for Mr. Kieu Sampon, do you have any observation or response to make to the application put forth by the prosecution? Since I did not see that you intended to make this observation, I did not grant you the floor earlier, but if you do have any observation, you may proceed, Counsel.
Thank you, Mr. President. Yes, indeed. I wish to make a few observations. The first, as a defense counsel, we never intended to insult anyone, nor the chamber, nor the parties. and even less the civil parties, and even less so the Cambodian people. That's my first observation. My second, as a defense counsel, our role is to represent our client, to assist him, and to carry his voice. There is nothing in this article published by the Phnom Penh Post, absolutely nothing that does not already exist in the arguments we developed before the Chamber, whether it be, and let me give you the references here, our findings relative to the questioning of the accused at E288/4. Everything here that we are developing in our submission can be found in summarized form in this article. Everything that we have said regarding severance, regarding issues around this, we have already stated it before this chamber when we examined, and I can say so because I am the one that raised these objections and I was the one who raised these problems during the document hearing on joint criminal enterprise. Let me start with this point because it's an important point, and I find it absolutely scandalous today that we're being criticized for having understood what was written in our decisions and we did not appeal a decision which seemed clear based on the elements we gathered from the chamber, and today we're telling us that we are changing our position. We developed our argumentation in an extremely in-depth way. I was the one at that hearing, so I can say so with quite a bit of certainty. When the documents were presented on the modes of liability linked with JCE. And what did I say then? I said that we had understood in the Kisampon defense that, and we said that we would refer to Annex E 124/7.3, which explains to the parties, which specified to the parties what the scope was of the elements discussed here in case 002/1. And now I would like to refer you to this document. It was in paragraph 5 of this annex. And this paragraph 5 of this annex explains that in this trial 00201, the forms of liability would be examined. A, liability related to the participation in a joint criminal enterprise, paragraph 1521 to 1525, except for anything regarding the grave violations of the Geneva Conventions and the subparagraphs titled the creation and the operation of the work cooperatives, the re-education of bad elements, as well as the elimination of enemies within and outside of the party, and the regulation of marriage. And we would only focus on the soldiers and officials of the Khmer Republic. Now, regarding subparagraph headed called special measures against specific groups, in particular the Cham, the Vietnamese, Buddhists, and of former officials and servicemen and their families. It is on the base of this annex, and I did not invent it. This is an annex that was drafted at the same time as the severance order of the chamber to explain what was going to be the scope that would be under consideration. We explained during this hearing on joint criminal enterprise relative to modes of liability that under these conditions we cannot understand that the other policies, whereas they had been excluded specifically from this annex, be considered now. That's the first point to explain why it is at that moment that the defense raised the issue, and it was even more so important because later on, the co-prosecutors, as well as the civil party lawyers, explained to you that it was not possible to simply speak about the existence, but we also had to speak about the implementation of these policies. And this gave rise to a very important legal issue, which we underlined. And this is nothing new. Maybe I should slow down. It's true that of course, I'm a bit worked up. So maybe, well, regarding severance, this is what was said. And I remember very, very clearly having said that if we hadn't appealed the severance order the first time, nor the second time when the Chamber issued a recent decision, if we didn't appeal this, it was in light of this particular point because we thought that things that we had to talk about were very clear. That's the first point. The second point, and this is nothing new, this is not the first time that we're saying this, we have kept on saying this since the beginning of this trial, as of when we started speaking about the preparation of the final submissions and the way that we were going to deal with the documentary mass. So I would like to reassure my civil party colleague, we were, of course, expecting a lot of documents in this trial. But since there are many, many documents, we were also expecting to have the possibility at the end of these proceedings, as happens in every trial, to confront the evidence, whether it be testimony, whether it be documentary evidence. We were hoping that we could bring up in detail every point and to shed light on these points for the Chamber. The 100 pages granted to us for our final submission do not allow us to have this full debates, which is necessary, and which is necessary at the end of the trial. It's not the first time we said it. We said it before, and what we said in this Phnom Penh Post article can be found in our submissions E288/4, can be found when you look at the written records, when you look at the transcripts of the hearings. It can also be found in our different observations. I remember also the trial management meeting, the first one, that in the number of pages granted to us, if you cannot take into consideration that we have never heard until now the defense's position, these 100 pages will correspond to nothing, because the prosecutor who has 200 pages, and we like to remind us that he has had the number of pages maintained, and we are stuck with 100 pages, whereas Yang Sari is no longer with us. That's just a side point. We stressed at that point that the prosecutor had already an introductory submission which corresponds to an unlimited amount of pages, which states his case. So this is not the case for the defense. So telling us that, and we have already told you that only having 100 pages for our final statement is not acceptable. The difference is that what we said in our submission, we also said in this newspaper article. And I'd like to remind you that the submission is public. Maybe our position does not suit the prosecution or the Chamber or the civil parties, but still, the positions that we have as defense counsel, of course, are not there to please everyone. Our aim is to defend our clients and to present our defense. Maybe you like it, maybe you don't like it. It's a pity, but that's the case in a trial. The analysis that we have of the case is not the same analysis as the co-prosecution. It's not the same, of course, as the civil party lawyers, and this is why we have a trial. This is why we are confronting each other. This is why we're confronting our different points of view. The only difference that we have today is that we have already presented what was already presented in the submission I'm speaking to you about, and by Kyusompa when he spoke, and by Arthur Verken, or by myself, or Kong Sam-eun. All of this was already said during the hearing when, of course, our microphones were not deactivated. Things were said and said again, and things that we said again publicly, as we had already filed our submission publicly, E288/4, so there's nothing new. So, of course, if you have to sanction us because we present our position, because we express our opinion as defense counsel, well, then, yes, of course. I'd like to refer you to the basic principles of the bar adopted by the 8th Council for the Prevention of Crimes held in Havana on 27 August to 7 September 1990, the basic principles relative of the UNHCHR specifying the basic principles relative to the role of the bar specify in paragraph 23, freedom of expression and of association, that lawyers, as anyone else in a trial, must enjoy freedom of expression. And we have this freedom of expression, and we have used it by all means through our submissions, through our microphones when it was possible, and through the press. So there is absolutely nothing new. Absolutely nothing new. Everything we said to the press, we already said before this chamber. We have already written it. So today, I don't know why. Well, I suppose I know why, but, well, the co-prosecutors want to turn this into a drastic event. There's no reason for this. We have expressed our position, and we explain our position. That is part of our educational strategy. You may call it strategy. But our position means that I have the right to say why my client takes such a position. And I am allowed to say so during the hearing, publicly through the press. Everything that we denounced in the press, we had already denounced them before this chamber. If this must lead to sanctions, well, I think then we have reached a very difficult juncture, and it will be really regrettable. Of course, you have the co-prosecutor's submission, you have the defense's positions, which are not new, and are always rest on either decisions by the chamber or on discussions during the document hearing. And I'd like to refer to all of the detailed submissions of Arthur Reckon when he was explaining why we would not participate in the document hearing. So once again, there is nothing new. Nothing new, except that this time, yes, maybe this hearing is a bit more important than, or was important than today. This trial is public. Anyone who wishes to check the transcript of this trial might be able to see what Kyusampan's position was, what were the arguments that were presented, and may notice that nothing new, absolutely nothing new, has been developed in this article, except for the fact that, of course, this position is stated in a newspaper. If that's a problem, I regret it. But once again, the hearings are public, our position is public, and as the defense counsel, we can explain why, we have the right to explain why we take such and such a position. Whether people believe that our position is not a right one, is erroneous, that is their right, as well as it is Kyusampan's right, in his position as an accused before your chamber, to also react within the limits of his possibilities and explain how he was reacting to this fact. So there's nothing new. There's no reason to sanction anyone except considering maybe that we are stand-in lawyers who can say nothing when they don't understand something, when they feel that something is unfair. We have explained often why we believe that the page limit is unfair, why we believe that we cannot discuss all of the evidence because of the limit of pages, why this is unfair, and we explained why it is unfair to cut off a microphone because we were expressing maybe certain ideas that did not agree with the prosecutor or with the chamber. But the idea, once again, in a trial, in a criminal trial, it's to have confrontation of visions, confrontations of positions, and you, the bench, will make the decision at the end. And of course, we won't have any other choice than to consider your decision based on the elements that we have provided to these proceedings. So what we said in this article is nothing different from what we said before. Well, if this deserves a sanction, well, this is really regrettable in regard to the defense's rights, and extremely regrettable in regard to the confrontation of different points of views in consideration of the legal and factual elements of this trial.
The President, Mr. Kung Samon, you may proceed. Councillor Kung Samon. Thank you, Mr. President. I know that we are now 10 minutes over the time, but I would like to have a brief observation concerning the application by the co-prosecutor and that of the lead co-lawyers for the civil parties. Overall, I believe that the application by the prosecutor was done in hazel, and I believe that the application to the chamber to impose any sanction on the defense counsel, I believe that this is not in accordance with the established procedures of requesting for such a sanction. It is important that the chamber is provided with sufficient ground to and the opportunity to examine the merit of this application. And as my international colleague has already mentioned, that what was published in the Phnom Penh Post was nothing new. It has something that we have already raised in the court. And in addition, the prosecution may have failed to look at the merit of the substance of this article, particularly taking the view from the defense counsel, a person who is representing the interests of the client. And I believe that any allegation that we are interfering in the administration of justice is the position that is misleading, and it is also a misrepresentation of the defense position. And on the point that the lead co-lawyers for the civil party raised, both the international and national lead co-lawyers for the civil party, who said that the civil party were disappointed with the decision to remain silent on the side of Mr. Khieu Samphan. And as the chamber and all parties are well aware that this tribunal is now bringing to trial Mr. Khieu Samphan and other leaders, and the exercise of his right to remain silent of Mr. Khieu Samphan is his inherent right. The trust and confidence of Mr. Khieu Samphan on the impartiality of this court is his sole decision. So I believe that the impact emanated from this court is of serious consequence for him. Eventually, he may be found guilty if he failed to follow the due process of international law. I believe that we are now not in a conference, or we are not in a school where the researchers come to conduct research. It is a trial in a court of law. That's why we have to look at every reliable evidence, and everyone has to have the trust and confidence in the process, particularly in the court. And it all up to Mr. Khieu Samphan to assess it along the way, and as a result, his cooperation with this court. Thank you, Mr. President. the President. Now, the hearing of the testimony of the witness has come to an end, and the Chamber has not yet scheduled the next hearing. So the Chamber decide to adjourn now and resume on Tuesday next week. The Chamber wishes to announce this scheduling for all parties and support staff. And the Chamber will announce the next scheduling order for the subsequent hearing to all parties and the public. And the Chamber will hear the remaining issue raised by the prosecutor and other parties to the proceedings on Tuesday, the 23rd of July 2013, starting from 9 o'clock in the morning. This is the information for parties and support staff of the court, as well as members of the public. Security guards are now instructed to bring Mr. Khieu Samphan and Mr. Nguyen Chia back to the detention facility and have them to participate in the proceedings on the 23rd of July 2013 before 9 o'clock in the morning. Mr. Nguyen Chia shall be brought to the holding cell downstairs, where audio-visual equipment will be connected to him so that he can follow the proceeding by remote means. The court is now adjourned.